Hi all, I hope you're all well. It's been a while. How are you doing? I hope you've missed me because I have missed you all. My name is Faareen. I am your host today at the latest with Law Simplified, and today I'm joined by a spectacular guest, Mr. John Dove. He's a Senior Crown Prosecutor, founder at National Speed Mooting Competition and Public Speaking Tuition. He joins us today to give us an insight into his journey to becoming a Senior Crown Prosecutor, as well as simplifying some of the laws involved, especially when prosecuting defendants, and the great work that he's doing for students through his fantastic initiatives, National Speed Mooting Competition and Public Speaking Tuition. So sit tight, grab a cuppa, because I always tell you to grab a cuppa and get comfy, because today we're going to get behind the exterior of Mr. John Dove. Welcome, John, to Law Simplified. Thank you so much for dedicating your evening today. It's a Friday evening, so thank you.
No problem. Thank you for having me.
Thank you. And how's your day been?
Oh, it's been a fantastic day. Thank you. Nice day off for once.
Oh, a day off. Okay. I feel extra bad now, and actually I envy you because I've had a bit of a hectic day in court today, so I've been running around. Now, a lot of you will have gathered from the introduction, John is a Senior Crown Prosecutor at Crown Prosecution Service, and we'll be calling the Crown Prosecution Service CPS for short. He is here today to help us understand the function of CPS and its relationship with the police. Now, before we go into that, John, I think it'll be really good if you give us an introduction into not only your journey, but a bit of an insight into your role as a Senior Crown Prosecutor, please.
Okay, no problem. So I'll start with my journey then. So like most people, I went to university at 18 years of age, and I went to the University of Liverpool to study law. Then at the end of my law degree, I went on to complete the Bar Professional Training course, BPTC. I think it's got a different name these days. Yeah. And I went through the usual process, like most people do, of applying for pupillage over a couple of years. And I found that I was getting very close, getting to final round interviews, but didn't quite get past the post. So I made the decision to switch and become a solicitor advocate. So I undertook the LPC whilst I was working as a paralegal, and then was offered a training contract with a criminal firm. And whilst I undertook my training contract, I completed the qualifications to obtain higher rights of audience in criminal proceedings as well. So I'm now a HCA, so High Court Advocate. So I'm a solicitor advocate for, if you want a different title for it. And that was several years ago now. So I practice in criminal law, started off in the defence side. So I did that for around 3 years or so. And now I've switched and moved across to the Crown Prosecution Service.
Okay.
As you've pointed out, I'm a Senior Crown Prosecutor. So that gives me a little more authority in relation to cases, particularly when it comes to decision making. So what that means is that I have the authority to authorise charges. I can withdraw charges, and of course, give instructions to external advocates as well. Now, you asked me about the role of the police and the role of the CPS, and that ties in with what I was talking about just there. So in terms of the police, as most people know, they investigate crimes. So their primary function is to investigate these crimes, perform the arrests and things of that nature. Where the Crown Prosecution Service come in is we are an independent body that prosecute these offences. So the police will perform the primary function, which is to investigate. And once they've done all that and they have gathered the evidence, that's where the Crown Prosecution Service come in, and we run these cases all the way through to trial. So for the majority of offences, we actually make the decision whether or not to prosecute. So one of the things that the CPS pride themselves on is we like to prosecute the right person for the right offence. Okay, so what we will do is we will look at a case at the outset. We will look at the evidence and look at what the most appropriate charge is for that case, give advice to the police, and then a charge will follow. Once an individual has been charged, we then prepare the case and we will run it all the way through, whether it's dealt with as a guilty plea or whether it goes all the way through to trial, and we will prepare the case during that time period.
Okay, that's quite interesting, actually. If we could just break down a few things there, and I think we'll be touching on the role of the CPS in much more detail a little later on. But in respect of, firstly, your journey, now you say that you went from defence to then prosecution. Obviously, you were a solicitor advocate. I mean, what sort of inspired your decision to do that? Is there anything specific that you really, is it because you wanted to have the experience of prosecuting, or was it something else?
Yeah, I think so. So I think I started in defence because that was, I think defending on cases, it can be quite interesting. So, you have a lay client that you deal with, and I think that's always, it always really appealed to me because I'd started off life working in civil cases. So I'd dealt with personal injury and things of that nature. So very sort of client focused. So I think that it was a natural transition, let's say, to go from personal injury through to criminal defence, whereby you're dealing with very fact-sensitive cases and you have that lay client. You've got that sort of conduct with an actual individual there. So that was what drew me to criminal defence. And I think what I like about these cases was challenging the evidence. So, it's all well and good, a charge being brought. That charge has to be proven to the criminal standard. When you're defending, you're looking at these charges and looking at whether that can be proven properly, advising your client, and then defending these all the way through to trial. So I really like the challenge of working in criminal defence. But after several years, I decided it was time for a change because, of course, there are two sides to this coin. And I thought that it was the perfect time in my career to move across and move to the Crown Prosecution Service. And I have to say, I'm very glad that I made the change. I've been there for almost a year now and thoroughly enjoyed my time at the CPS.
That's fantastic. You're persuading me, John, because I'm dealing with civil work at the moment. So, it's quite appealing, actually, just hearing you talk about it and just seeing that, it's very stimulating.
I think so. I think they really do go hand in hand. So I think that there's a number of areas of law that help each other out quite well. So that would be, for example, personal injury, general civil work, and of course crime do go hand in hand. Yeah.
And I think the takeaway point for students here is that your career can be quite fluid. If I'm not sure if you agree with me there, John, in 100%. That you really start off somewhere, let's say, one end of the spectrum, and then you could end up on the other end, really doing different types of work than what you thought you would do initially. I think that's a great thing about being a lawyer, being, right involved into the heart of law, whether that's civil or criminal. You can really sort of change ways. One thing that you would say to students at this point in respect of, one takeaway point from your journey, let's say. I think
I would say is don't tie yourself down. So I quite often have students contact me and ask, well, I want to do this area. What could you advise me about this? But I'm sort of interested in this. I would say keep an open mind. You do not know where you're going to end up. I mean, certainly when I was working as a paralegal doing personal injury cases, I never thought I would then go on and become a senior Crown Prosecutor. So you really don't know where your career will take you. So I think the best piece of advice I could give is keep an open mind all the way throughout. And when opportunities present themselves, jump at them, because taking on an opportunity can lead to so many other things down the line. So it really is about being open-minded and jumping at any chance to really excel.
That's really great advice, actually. So yeah, open mind and really make the most of any opportunity that comes your way. Now, if we touch on the topic of students, there's quite a lot that you're doing for students at the moment, John. Why don't you tell us a little about that? Yeah. Firstly, touching on your both of your initiatives, so National Speed Mooting Competition, but also actually talking about the public speaking tuition that you've set up and what that really involves.
Okay, so we'll start with the National Speed Mooting Competition. So this was something that I set up around 9 years ago now. And the idea of this was it was designed to be a competition, a mooting competition that's slightly different to your standard mooting competition. So when I was at university, one of the problems I found was that when it came to mooting, you were often in a pair. And unless you knew somebody that was particularly good at mooting and they wanted to have a go, it was difficult to find partners. So what would happen is I would be given random partners. You would go into a mooting competition, and if one or the other person didn't quite perform up to par, the team would be brought down.
Yeah.
So I thought there needed to be some sort of external competition whereby people were judged individually. So the idea of the Speed Moot was that it would be an individual competition. So people would enter on their own. They don't represent their university. So you don't need to go through any selection process or hope that you're in the right clique and that you'll be put forward. You enter on your own accord. And that is the problem with a number of competitions. Unless you're in with the right people in your mooting society, you may never find out about external competitions. So you're on your own. It's speed mooting, so submissions are limited to 7 minutes. The idea was that all of the materials were provided as well. So all of the skeleton arguments are pre-drafted, all of the legislation is included, all of the case law is included in the bundle. So there's no drafting and no research required whatsoever, which can put off a lot of novice mooters. So mooters are tested purely on their oral advocacy. And what we did was for the original competitions, we sent out the bundle at 5 p.m. the night before. So it's like being in practice when you receive a last minute brief and you've got no time to prepare.
Yeah.
And also we have practicing barristers and solicitors acting as the judges to try and make this as realistic as possible. So this would all take place in a single day. So we set up the first competition back in 2012. And it was a relatively small competition. I think we had around 30 people or so. But it was such a huge success that we decided, well, let's make this bigger. And for the second year, which was the 2013-14 academic year, we made it a national competition, held it at Salford University, and it was open to 128 competitors.
Oh, wow.
And yeah, and year on year, this competition has grown and grown and grown. And I saw last week when the pupillages were announced, in terms of, who was obtaining pupillage, a lot of the people that were putting out messages saying that they'd received pupillage, I recognized the names because they'd, competed previously at the National Speed Mooting Competition. So it's nice. I'd like to think that this sort of opportunity is helping people to build their CVs.
Absolutely.
So the idea of the Speed Moot is it's a chance for anyone, whether they're a novice mooter or whether they're very experienced, to have a go in this competition. And it really is a level playing field because our 2020 champion had never been involved in a moot in his life before. And the 2019 champion had done lots of the sort of big name external competitions. So it's good to see that both experienced and inexperienced mooters alike can really do well in these competitions.
Can I just ask you a question there? How many rounds are there then to get to?
So there are 7 rounds. So it works as a knockout format. So we go from having 128 people down to 2 finalists in a single day.
Okay. Oh, a single day. Oh, wow.
Single day competition. Yeah. So it's very frenetic.
Yeah, absolutely. And keeps you on your toes, right? You've got to keep on performing. And I think that's a really good thing, actually, because it allows you to prove. Yeah,
absolutely. And what we find as well is that because the competition is judged by practitioners, they normally tend to give advice to the students, both the winner and the loser of each round, after a moot. So you'll find that somebody who does a performance in round 1 will receive some feedback. They go through to receive feedback in round 2, round 3, etc. So the performance they give in the final is probably nothing like the performance they gave in round 1 because of that feedback that they're receiving throughout the day. And students tend to say that they really find that advice and that feedback very, very helpful.
That is fantastic. Yeah.
So that's how we started. So we started off running competitions, and then obviously in 2020 we had a pandemic, and it would be very difficult to run these competitions in a sort of in a face-to-face format because we always run these in universities. So I decided to take the Speed Moot online. So what we did was we started off with some Q&A sessions. So we had sort of barristers and solicitors come on Zoom and perform Q&A sessions for students. And we did these on different practice areas and different types of professions as well. And then from there, I decided to run some competitions online as well. So in 2020, we had a smaller version of the Speed Moot, which we called the Winter Cup. So effectively the same competition, the same format, except it was just in a slightly smaller format. And we also did a plea and mitigation competition as well earlier this year. First time we've ever done a plea and mitigation competition. And we're currently in the process of our national speed mooting competition, so the flagship competition, but we're running it on Zoom at the moment. But we've actually moved beyond simple competitions now and have what we call an advocacy club as well. So it takes away the competitive element. And the idea of the advocacy club is for people to practice their advocacy. Now, this isn't limited to students. It's open to law and GDL students. It's open to bar course, LPC students. It's open to graduates. It's open to master's graduates, PhD students, and also practitioners. So we actually have practicing lawyers in the advocacy club as well.
Okay.
And the way it works is we have 10 meetings a year, and we always meet on the last Tuesday of the month. And we focus on 5 different types of advocacy. So we focus on speed mooting, witness handling, which is always the most fun, plain mitigations, general public speaking. And what we do within the club is at the meetings, we will separate the members into groups of 4 normally. And within the mini groups, what will happen is people will have a go at whatever type of advocacy it is that week. So for example, if it's speed mooting, there will be 2 moots that take place within a breakout room. And after the moot, members will give feedback to each other. So it's very much peer-to-peer learning. It takes away the pressure of performing in front of a lecturer or in front of a practicing solicitor or barrister. And it really allows members the chance to practice, improve their confidence and get better. And the feedback I've had so far from people is that they really are improving in leaps and bounds.
Absolutely. Practice makes perfect, right?
It really does.
The better you get. So it's a great opportunity. And so, I mean, you're doing so much there, but you've also got your second initiative, haven't you?
I have, yes. So the second is publicspeakingtuition.com. So this was something I set up some time ago. And where I got the idea from this is I'm a member of the Liverpool Speakers Club, and I'm actually the president of Liverpool Speakers Club now. And several years ago, we had a guest attend one of our meetings, and he said to me, like the way that I delivered a presentation, would I be happy to give him some tuition? And I thought, well, there's probably a lot of people that want more direct tuition. So I set up the website and offered tuition to individuals. And this isn't limited to people in the legal field, although I do offer this tuition to people, lawyers and law students, etc. And what I do is I provide guidance on how to perform, whether it's general public speaking or, of course, presentations. And I help people improve their confidence and improve their ability to perform as well. So I find that the people I work with come from, sort of a wide range of backgrounds. So one day I might be helping somebody prepare for a wedding speech. The next day I'm helping somebody prepare for a pitch to an angel investor. So I deal with a number of people who have startup companies, for example. And I think it's a good way for me to help individuals improve, because there's a lot of people out there that don't have the confidence when it comes to presenting, or they might have the confidence, but they don't know quite how to get that polished delivery. So what I do is I help people improve in that regard. And I do sort of one-on-one lessons and, of course, group lessons as well. And it's nice to see somebody come in, maybe, a little rough around the edges. And then after so many sessions, they're able to deliver very good presentations.
Very good. My God, how do you have the time to do all of this, John?
I have no idea. I'm very busy.
But you're running on, that's not 24 hours, because I tell you, I can only imagine that you probably do work through the night to keep, all of these commitments. So I do respect you and I commend you for everything that you're doing. Thank you so much for everything that you're doing for students. And I think it's a great moment right now to congratulate every single person who's obtained Pupillage. So many congratulations to all of you. I think it's a fantastic achievement, of course, and it's really competitive. It's very hard to get. Given that I've gone through the cycle myself. So absolutely hats off to you all, and many congratulations from Law Simplified.
I would echo that as well. And more importantly as well, to those who haven't, I would say, keep on trying. As you've said, it's very difficult. So it's just a case of jumping back on the horse and having a go again. Each cycle that you go through, whether it's just doing the applications, whether you get interviews, you'll always find that you can improve time on time. So don't be too despondent and keep on, and best of luck.
Absolutely. And again, we echo that as well. So, and of course, I think the great initiatives that John has set up for us all will, of course, come to a lot of value for us. So do get involved with everything that John's up to. I mean, how do they get involved? How do people actually get involved into the Speed Mooting national competition?
Yep. So we have a website, which is speedmooting.com. So I try and keep the website nice and simple so there aren't too many tabs for people to get lost on there. So what you can do is if you go on the website, normally if we have a competition coming up, there's a link at the top. So you'll click that and you can go through. If you want to join the advocacy club, go on the website again, speedmooting.com, click the link for advocacy club and you can sign up through there. All the information is on there. Or if you want to be notified about any competitions that we have coming up, any events about the advocacy club, go on our contact page. So it's speedmooting.com/contact. Fill in your details and you'll be added to the mailing list and we'll update you whenever we have any new events.
Fantastic. So go on, do it right now and get involved in all the different types of mooting and advocacy exercises that are available through John's initiatives. Thank you so much again for that, John. So John, we're now going to move on to a bit of law. Of course, what we want to do to start off with really is to really get an insight into how you prosecute cases. Now, there's obviously a test involved, a legal test, shall we say, and that's called the full court test. Yes. Could you break that down for us, please, and really inform our audiences of what that involves?
Yes, so the test you're talking about comes from the Code for Crown Prosecutors. So that governs the way in which we deal with our cases. So the full code test must be satisfied before we can bring a charge and, of course, for us to continue with a charge as well. So the full code test is separated into two parts. We have what's called the evidential stage and we have the public interest stage as well. So when it comes to the evidential stage, we must be satisfied that there are reasonable prospects of a conviction. So in plain language, what that means is that we must be satisfied that either a bench of magistrates or a jury properly directed would be more likely than not to convict the defendant. So it's not the same as the criminal standard of proof. It's not quite that high, but we still need to be satisfied that there are reasonable prospects of a conviction before we can bring a charge. And we also keep that under review all the way throughout the case as well. If that is satisfied, we then move on to the public interest stage of the test. And this is where we consider whether it's in the public interest to consider a prosecution, to bring a prosecution, I should say. And there's a number of factors that we take into account. So we look at the seriousness of the offence. We look at any harm caused. We look at the age of the offender, the maturity, any mental health issues that may be relevant. And we have to consider all of these factors and we'll consider them as a whole. Sometimes one factor may outweigh all of the others. And we look at this on a case-by-case basis, but we need to consider all of these factors as a whole. And if we're satisfied that both stages of the test are satisfied, then of course we can bring the charge.
Okay. I mean, if we just break that down, if we may, John, just in respect of the evidential stage, then you touched on a few things. What does that actually involve? So is that the evidence that the police will pass on to the CPS?
That's correct, yeah. So what happens is, as I say, the police investigate these offences and they will send all of the evidence across to the prosecution. Now, evidence in a criminal case could be witness statements. It might be exhibits. So, for example, let's say if it was a possession of a bladed article, they will send through a photograph of the knife. That would be evidence in a case. There may well be photographs of injuries. It could be in a drug driving case. It would be the specimen that shows how much of a specified drug was in the blood. So when we're considering whether there are reasonable prospects of a conviction, we're looking at the evidence. So we're not considering anything else, simply the evidence. But we also need to look at, for example, what defence might be raised. So the way that we deal with that, particularly if we're looking at a case at the outset, is we would look at what's been said by the defendant in interview. Now, for example, if a defendant says he's going to raise self-defence, that, of course, is something that we need to consider, and there may well be further lines of inquiry there.
Okay, so, for example, if self-defence is raised, what you would then look at is what evidence substantiates that.
Absolutely.
Is that made out? And if it is made out, I assume that would then, of course, either still go through to trial for it to be determined at trial, and or if you're satisfied beyond reasonable doubt, is it that you would then just not bring a charge against the defendant? Is that how that works?
Precisely, yeah. So if we looked at that and we thought, well, there was some merit in the self-defense to the point that there would no longer be a reasonable prospect of conviction, then of course we wouldn't bring the charge.
And just in terms of the public interest, now that's the second limb of the test. So both limbs need to be met,
yes,
as I understand it. Okay. And so the public interest aspect that you said you look at not only what impact is upon the society if a charge is brought or is not brought, and you look at the other factors such as the age of the defendant. What if the public interest element isn't satisfied? Does that mean that it's no charge brought? Is that how that
Precisely,
works?
yes. Yeah. So both aspects of that test must be satisfied. So you may have the strongest case evidentially, but if that public interest test is not satisfied, then of course we wouldn't bring the charge in that case.
I think what really comes from this actually is, especially for someone, a layperson who perhaps has no legal qualifications, of course, and has not had any experience with CPS, is that there's a set process, there's a thorough process that CPS has to follow before a charge is brought. Just touching on then the relationship between the police and the CPS then, what is that relationship? Can you describe that for us?
So we are very much two separate bodies that work independently. So as I pointed out, the police will investigate these offences at the outset. They will gather the evidence, they will speak to witnesses, and then they pass that all across to the CPS for us to consider. And we will look at that evidence as we firstly consider charge, and of course, whilst we're pursuing the case as well through to trial. But during the investigation, there will be correspondence between the police and the CPS, but very much maintaining our independence throughout.
Absolutely, and that's very helpful actually. So not only do you work as a team, but you are independent to one another and you have no influence at all upon each other. It's a complete separate...
we're both completely independent of each other.
Okay, great. I think that's really important to really touch on, because a lot of people see the face of the criminal world or the criminal justice system as the police or the CPS being as one, but actually they're not. And there's a set process and actually a legal test. So CPS themselves have to ensure that a legal test is satisfied before bringing a charge against someone. I think that's really interesting. And how about dealing with murders? And very finally, just touching on stuff that perhaps a lot of people might, really find interesting. I find murder interesting, not committing it, of course, but obviously looking at, oh gosh, I better put that out straight away. But just looking at these programs on the TV, it's an interesting, bit of area of law. Is that the same process, or is there perhaps a higher threshold or more attention that needs to be given when satisfying the test?
It would be exactly the same. So if you find yourself in a position whereby you were able to apply the full code test, then the standard is exactly the same. You need the evidential stage, which is that there must be a reasonable prospect of conviction. And of course, it must be in the public interest to bring the charge. There are cases whereby the threshold test, which is a slightly different test, might apply. I won't go into that today because it's slightly too confusing, but for all intents and purposes, if all the evidence is there ready to go and you're applying the full code test, then it's exactly the same standard that applies.
And very lastly, and we're going to now move on to something really exciting and fun, which is a quick fire round. How would you say, these programs on TV that we see, I think one example being Line of Duty, although we don't really get the court side of stuff, I don't think anyone's ever been featured in court on that program. How realistic is that?
Well, I've never seen that particular program, but as a general rule, most courtroom dramas tend to be pretty unrealistic. Because what you'll tend to find is you have, lawyers walking around the courtroom, which we don't do in this country. We stand up, we sit down, and that's it. We don't approach witnesses. In America, they might do that, but they certainly don't in this country. And normally the timescales are never quite right. You tend to find somebody's on trial a week after committing the offence. And also, the trial process itself is quite staggered. You'll see a prosecution witness, then a defence witness, then a prosecution witness. So they're not too realistic, but what I would say is don't panic, enjoy the shows. It's pretty difficult when you're a lawyer watching these shows and you go, that's not right, that's not right, that's not right. So if you're not a lawyer and you watch them, just enjoy them.
Great. Okay, thank you so much for that, John. I think that's really helpful, especially with respect to the bit of insight that you've given into how the CPS works. I think that really gives us a lot of clarification, even to me, because I don't actually practice criminal law. So it's very good to get an insight into that. So now we're going to move on to something more exciting and fun, which is we're going to get to know you a bit more. So there's a few questions actually that I want to ask you, and I think these questions perhaps are those that many won't expect. And I think the first one that I want to start off with is your favourite food. So why don't you tell us, what do you like to indulge in?
I would say pepperoni pizza is my favourite food.
Okay. Anything else, or is that your main go-to?
Yeah, I'm starting to get into sort of Chinese and Japanese food now.
Nice.
So, different forms of teriyaki chicken with rice or noodles, that kind of thing. I'm only just on the simpler stuff for now, but I'm not really one that's really into many foods, I should say. So it doesn't really venture much beyond sort of pizza, chicken nuggets, burgers, things like that.
Oh no, absolutely, and they're delicious. So absolutely.
Why not?
Yes, why not? So your most, I think your bizarre experience. Why don't you share your bizarre experience with us? Perhaps either whilst practicing or maybe during whilst undertaking your journey to the bar. Is there something that you recall?
Yeah, let me think about a bizarre experience. I think one of the most interesting ones I had was I was defending somebody on a possession of a bladed article charge one time.
Okay.
And his defense was that he had a reasonable excuse for having this particular blade with him. And the reason being was that he was involved in whittling. So what that meant is he cut shapes out of wood. And so as we were presenting his defense, I presented some of his, some of these little statues that he'd made to the bench. So it was a bit of a bizarre experience presenting these little wooden shapes to a bench of magistrates as an exhibit.
Oh, wow.
So that was quite a bizarre experience.
And your biggest regret then?
I think biggest regret, and I think this is probably quite a good piece of advice for students, is not getting involved enough with extracurricular things when I was at university. So, I see people now, talking about, they've got various roles within their mooting societies, bar societies, law societies. And I think I didn't get involved in that anywhere near enough when I was at university. It's a good way of building up skills that you need for life, I think, and also building your CV. So, you asked about practical advice before. I think the biggest piece of advice I can give is get involved in things like that. I think it would have been helpful for me to do things like that from an earlier age.
Absolutely. And I think we have a fantastic platform here, National Speed Mooting Competition, right at our doorstep to get involved with. So absolutely, fire out your emails to John and do subscribe onto the mailing list so you're never left out and you're always aware of what's upcoming and all the upcoming competitions. I think that concludes the interview today, John. Thank you so much for joining us.
No problem at all.
Any closing comments or last thoughts or closing thoughts rather?
Yeah, final thoughts. I think I would just like to say thank you for having me on the podcast.
No worries.
Yeah, I think, what I would say to people is if this is a career that you want to go into, I think you really can get into this. It's a very difficult career to break into, very difficult profession to get into. But I think, with the right mindset, putting the hard work in, you can make it. And what I would say is, it can take some time. Some people go in straight away. Some people it takes 5-10 years to get into the profession. Just remember, it's a marathon, not a sprint. You're going to have a long career here. So don't worry about trying to get in too quickly. Enjoy the process and have fun along the way.
Absolutely. And we had a guest recently who'd said the same: patience, patience, patience. Keep patient, keep committed, and just keep working to improve yourself. And one day you'll get to your desired result and goal. So thank you so much for joining us, John. Can I just say, as I'm sure you're all aware, Law Simplified is on all the social media platforms. Do follow us. We're on LinkedIn, Instagram, Facebook. We're even on TikTok now, so do follow us straight away. Do head onto our website at www.law-simplified.co.uk. We are publishing content on a regular basis, articles, videos, podcasts, all available for you there. Just a touch of a button. So do get on there and do check out all the great stuff that our content creators are publishing at the moment. And of course, do follow John. John is on LinkedIn. Both his initiatives, so National Speed Mooting Competition, again, that's on LinkedIn, Facebook, Twitter, Instagram. They are on all the social media platforms as well. So follow Law Simplified and follow National Speed Mooting Competition, as well as Public Speaking Tuition. And do fire out your emails to John. Thank you so much, John, for joining us today.
Thank you for having me. I would say look out for the handle @SpeedMooting on Instagram and Twitter.
Yeah. Okay. Right. So we've just been signposted there. I'm going to go on it right away. So
And once again, I would encourage everybody to follow Law Simplified. You've got lots of fantastic resources, so it's really well worth watching the videos.
Thank you so much. Thank you all, and have a great night.